Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 25-3024. United States of America versus Josue Eduardo Rodas, appellant. Mr. Farley for the appellant, Mr. Hansford for the appellee.
Morning, Mr. Farley, whenever you're ready.
Good morning, and may it please the court. Matthew Farley for Mr. Josue Rodas. I'd like to reserve 2 minutes for rebuttal. Mr. Rodas finished his one-day term of supervision on July 13th, 2022. After that, the district court had no jurisdiction to supervise Mr. Rodas or bring him into court for revocation proceedings. The district court's conclusion otherwise was wrong. At Mr. Rodas' sentencing hearing, when the court began to impose a perfectly lawful sentence under the DC Code, it was the government that insisted that the court must impose a period of probation. It was the government that suggested that the period of probation should be 1 day, and it was the government that suggested suspending the period of probation. Despite these invited errors, the government never filed a Rule 35 motion or an appeal. Only now, when Mr. Rodas seeks to have the court enforce the lawful terms of his judgment, does the government choose to act, seeking remedies that are no longer available. Mr. Rodas asked the district court, and now asks this court, to lawfully execute his criminal judgment, and doing so can only have one result. He is no longer subject to the district court's supervision. This court should reverse and remand to the district court with instructions to order Mr. Rodas discharged from supervision.
Mr. Farley, so I'm concerned about our appellate jurisdiction here in this case, because what the district court's order is not final, and or is at least arguably not final, and I'm not sure how this fits into the collateral order doctrine. Why does Mr. Rodas not have to wait until these revocation proceedings conclude?
So I think there's 2 reasons that Mr. Rodas doesn't have to wait until revocation proceedings conclude. The first being that I would maintain that this order is final. This is a motion to terminate supervision because of a lack of the district court's supervision that could have been brought before a revocation petition. It could have been brought the day it was filed. It could have been brought after, as it was. The district court's order that it had jurisdiction to supervise Mr. Rodas is a final order. It's the closest statutory analog is a 3583E motion, which are reviewable by this court as final orders.
But they're very different. This is Judge Randolph. They're very different because once the district court denies a motion to terminate supervision, there's nothing more for the district court to do. But that's not true here. I mean, the result of the denial is that there'll be a trial about whether he, in fact, violated the conditions. So the cases that you cite are very, very different in terms of finality.
Yes, they are different. This is a unique position of first impression for this court. I would say that the result of the denial of Mr. Rodas's motion is actually is not the what will be the revocation hearing. That revocation hearing is a result of probation's petition. The result of Mr. Rodas's motion being denied is just that he's continued to be subject to supervision in the court's jurisdiction. But in the alternative, I do think Mr. Rodas's motion and the court's order satisfy the collateral order doctrine. Under this court's decision in Trabelsi, we looked at the logic of Abney, and I think Abney is on at least 3 legs, if not 4 here. Abney, which is the Supreme Court's decision giving interlocutory jurisdiction over double jeopardy motions, says that when you're challenging the court's ability to hail you into court at all, which is exactly what Mr. Rodas is doing here, that is an important and inseparable order that is not reviewable on appeal later, because you're being subjected to the burdens, the harm, the stigma, everything that comes with further criminal court proceedings.
That's no. Go ahead.
No, go ahead. Go ahead.
I was just going to say, but the situation, it seems to me, is very difficult to distinguish from the run-of-the-mill motion in criminal cases to dismiss the indictment for one reason or another. It doesn't state a crime. There's no jurisdiction. There's this, there's that, and everything else. And routine motions in criminal trials cannot be appealed. Double jeopardy is an exception, and that's because of the constitutional aspect to it.
Yes, yes, Your Honor. That is, you're obviously correct that the general motions brought pre-trial are not immediately appealable, and the Supreme Court is instructed to interpret interlocutory jurisdiction criminally strictly. But the reasoning behind that guidance to interpret it strictly is for the public interest in a speedy trial, for the public interest in proceedings moving forward. We're post-conviction. The court's reasoning and justification for why interlocutory jurisdiction is interpreted so strictly in criminal cases I would argue inapplicable, but at least much less applicable in a case about revocation on supervised release.
But how, Mr. Farley, does your argument intersect with the many cases that say there's no general right not to be tried, right? So we have collateral, order review when things are really important, if it's double jeopardy or there's a speech and debate clause issue. I mean, where there's some specific constitutional limitation on moving forward. But there are lots of cases that say there's, just no general right not to be tried. And that, it seems like what you're arguing for here for Mr. Rodas.
You're correct, there is no general right not to be tried, but as Your Honor just listed, there are constitutional protections for specific situations where you have a right not to be tried, where you have a right not to be hailed into court.
So what's the right here then?
Sorry?
What's the right here that Mr.
The right here is analogous to the double jeopardy right not to be hailed back into court after you fully completed your sentence. And analogous to one of the rights that is already recognized by the Supreme Court is the general test that courts of appeals, including this court, look to in whether or not interlocutory jurisdiction is appropriate.
I'm possibly persuadable that a typical motion to terminate release. I'm not sure you can terminate a supervised release that doesn't exist. And your argument is that the supervised release doesn't exist and never existed.
Yes, Your Honor, our argument is that the supervised release term has become a nullity. That's the language of the DC Court of Appeals.
How do you terminate something that was never alive?
I think what Mr. Rodas would be asking is not for the actual the supervision to be terminated, but for the court to terminate its attempts to exercise jurisdiction over him. I think would be that we're dealing with a unique situation where
that sounds like a habeas petition. If a court tries to impose some kind of if any government entity tries to impose some kind of authority over somebody without jurisdiction, that seems like a habeas motion.
It sounds like one, but this court's opinion in Marsh instructs that the proper remedy for arguing that a court doesn't have jurisdiction to exercise supervision over you is to a direct appeal to this court.
So you could have challenged the validity of the supervised release the first day of his supervised release, or the first day that the court attempted to supervise him on release. I think you also could have challenged it as soon as the sentence was imposed, and arguably you had to. But even putting that aside, I don't understand how you can get around the time limits for challenging an unlawful sentence. I don't know how you can get around those time limits.
Your Honor's correct that Mr. Rodas could have filed this motion I would say on July 14th, 2022, when if there was any attempt on that day to exercise jurisdiction over him. But I would argue he had no obligation to. The jurisdiction an argument that there is no jurisdiction can't be waived. The error is always plain. Mr. Rodas waited or didn't file this motion until possible re-imprisonment became a possibility. It's perfectly reasonable, and the Mr. Rodas had no obligation, and the government hasn't said in any case stated that he had an obligation to do so beforehand.
Let me ask maybe just one more question. Even if you can appeal the denial of a motion to terminate supervised release, you can't appeal a denied motion to dismiss supervised release proceedings. I don't think. Let's assume that. And it seems to me that in your appellate brief, your opening brief, that's what you appealed. On page I, you say the ruling under review, the one and only ruling, is the order of the district court denying defendant appellate's renewed motion to dismiss supervised release proceedings. And then on page Arabic numeral 1, you say that the issue presented in review is whether the district court has jurisdiction to hold revocation proceedings for Mr. Rodas. And then in the argument section, you say the district court should have dismissed the revocation proceedings. For example, you say Mr. Rodas is no longer under supervision, which assumes that he was once under supervision. But I looked at the district court docket. I think, to be fair to you, it looks like you made a motion to dismiss and in the alternative, a motion to terminate, which you can kind of think of as two motions. But then I think arguably you only appealed the denial of the first motion. You only appealed the denial of the motion to dismiss the revocation proceedings.
To tackle your question in a few parts, just first, Mr. Rodas does concede he was under supervision for that one day that he was on probation on July 13th, 2022. To move further along, I think what Your Honor's pointing out is the difficulty with what you earlier pointed out, that how do you terminate something that doesn't exist? What is how is it a motion to dismiss the proceedings? Is it a motion to dismiss supervision generally? Mr. Rodas is appealing both the district court's refusal to or denial of his motion to dismiss supervision generally, which would include those revocation proceedings where he was being held into court. Mr. Rodas has also challenged the reasoning behind the district court's motion, denial of his motion to terminate. And so Mr. Rodas's motion includes both of those.
Mr. Farley, this is Judge Randolph. Has your client been tried on the Fort Meade charges?
The Fort Meade charges were disposed of. It says closed administratively on the docket. I believe that might be some posh term used in the District of Maryland I'm less familiar with that I think might invoke some sort of plea agreement that I'm not completely clear on.
So he hasn't been tried on these charges?
No, he has not. That case has been closed.
Okay. Yeah. Were there other charges that were pending against him?
Yes, Your Honor. There were other state charges in Maryland, I believe, all in Prince George's County. So, some of which have been resolved. Mr. Rodas is currently on home incarceration for one of those charges.
He's currently in prison?
No, he's on home confinement.
Oh, well, okay.
So he's subject to a sentence from Maryland State Court, yes.
Okay.
Mr. Farley, just one other question for me. Is there any evidence that he properly served his 1 day of probation in the record? Like, is there any, do we know anything about that 1 day of probation? Like whether he met the criteria for probation or whatever that was?
What I would say is that to show any sort of violation or problems with that 1 day of probation would be the government's burden. There's nothing in the record indicating that there was any sort of violation or anything improper happened on July 13th, 2022. That would have resulted in that meaning that his probation did not complete as written.
See if Judge Randolph or Judge Walker have any other further questions? No?
No.
Okay, thank you. Mr. Hansford, are you ready?
Sure. Good morning, and may it please the court, Eric Hansford for the United States. This court lacks jurisdiction over this interlocutory appeal. The revocation proceedings remain pending in the district court, and denial of a motion to dismiss a revocation proceeding is a classic non-final order that can be heard after the revocation proceedings conclude, but is not subject to interlocutory appeal. And I think the defendant is offering what I understand to be two separate jurisdictional theories here. One is the motion to terminate theory, and one is the collateral order doctrine. So I can just address those in order. So as to the motion to terminate, I think there are two problems with that theory. First is that the cases that say a motion to terminate is appealable are cases where, as Judge Randolph's questions were going to, where the proceedings in the district court have been concluded. So the classic statement of when something is final, this comes from Midland Asphalt as well as other cases, is that a decision that ends the litigation on the merits. So in the cases that are finding jurisdiction to review a motion to terminate, there's nothing else pending in the district court. Here, by contrast, there is still the revocation proceeding pending in the district court. Therefore, it's not final and instead has to go through the collateral order doctrine to get review. The second problem with relying on those cases, to Judge Walker's questions, is that the issue that's being pressed on appeal is not the motion to terminate. The motion to terminate was, I think it was largely an afterthought in the litigation. It was really only articulated in the reconsideration litigation, but the district court, this is on A25 of the record, which is the minute order that denies the reconsideration motion. It describes the motion to terminate as, even if jurisdiction exists, defendant's supervised release should be terminated as unsuccessful. And the defendant was making that motion on the theory that supervision was doing more harm than good, that he was had a job and he was being pulled out of his job to do drug testing and mental health testing and things like that. But that's the motion to terminate argument, which is that I shouldn't, even assuming you do have jurisdiction, I am on supervised release. You should terminate my supervised release early. And under the statute that looks at the interests of justice and how the person has done on supervised release, it is not an argument that I was never on supervised release in the first place. And so that sort of argument that I was never on supervised release in the first place, that is brought through a motion to dismiss. And that's the only argument that the defendant is actually pressing on appeal. He's not arguing now that the district court should have terminated early based on the factual circumstances underlying my supervised release.
Do you agree that if there had just been a one line motion that didn't mention anything about the revocation proceedings and it just said, I move to terminate my supervised release, that would be appealable when it was denied?
Not if the revocation proceedings are ongoing. And I think that is similar to the circumstances in the unpublished Fourth Circuit cases that we cite, Terry and Muhammad, where there's a revocation proceeding that's ongoing, and then the defendant asks to change aspects of his supervised release. That would and the Fourth Circuit in both cases very quickly says, well, because there's still stuff pending in the district court, you can't immediately appeal that. You have to wait for the revocation proceedings to resolve.
And I guess I mean, I know no district court in our district would do this, but if the district court just took forever to do the revocation proceeding, there'd be some way, I don't know, something like mandamus or something something similar.
Right. So there, yes. So mandamus, I think, is kind of the classic remedy when there is unexplained lengthy delay. And that is kind of what could be sought. I think it's notable here the district court, when it denied at the hearing, when it gave its reasons for why it was denying the motion to dismiss, it was ready to proceed with the revocation proceeding. It was ready to go right then. And it was the parties who asked that the revocation proceeding wait to see what happens in the pending state court cases. Now it's been denied, it's been delayed further at the government's request to see what happens in those revocation proceedings. But on the day of the revocation, it was scheduled for a revocation proceeding. The district court denied the motion to dismiss, and the defendant and the government together asked, don't go forward with the revocation proceeding.
Let's say we don't have jurisdiction, and then when the time is right, the question of whether the sentence was allowed to impose prison plus probation plus supervised release gets before us.
Sure.
And let's say we vacate that sentence. Could the government argue at resentencing that now that we know what his behavior has been since sentencing, that the court should impose a longer, harsher sentence than it did originally?
I've not looked at that specifically. I think we could. I mean, I think Pepper stands for the opposite proposition, which is that where you're resentenced after a long delay, the district court can take into account good behavior between the original sentencing and the later sentencing. I think the argument would be the same on the government side, but I think there's also an earlier issue that the government could argue for at resentencing, which is the kind of little two type issues, which is that if the government was not able to get supervision over the defendant through the DC code provisions, then that might well warrant a longer term of
You'd also have a problem under North Carolina versus Pierce, a due process problem where if it had been a direct appeal, you can't get a higher sentence on retrial.
Well, you could get a higher sentence if you're knocking out what the district court understood to be part of the sentence. And I think that's what little two goes through. I do think it's important. The hypotheticals, I don't think are occurring here because as I understand the defense position, they don't want a resentencing. They don't want this court to vacate under circumstances and send it back for resentencing. In fact, and I suspect that's because the sentence already reflects, and the government is not challenging, a significant windfall to the defendant, which is that the supervised release term, the incarceration term here was 16 months of immediate incarceration, then 14 months of suspended incarceration. But
I agree. I think that's what Mr. Farley is proposing. I mean, he's proposing the remedy as you described it. But just because he wants it doesn't mean he'll get it. And then, I mean, I think some of these, Little did not end up in a better place after he won his appeal.
Right. That's exactly right. And I think that Mr. Farley, I don't want to speak for him, but as I read the reply brief, he does not want to go back for resentencing, maybe because of those sorts of concerns. I did have one more thing I wanted to say on the collateral order doctrine that may be helpful, which is that when you're looking at this right to trial, the double jeopardy type claims, Midland Asphalt, from Justice Scalia's opinion there, recognizes that almost any right could be, with wordplay, reframed as a right to trial. But then he says, what we are looking for is an explicit statutory or constitutional guarantee that trial will not occur. That's what triggers this right to trial under appealability under the collateral order doctrine. And that does not appear to be satisfied here. He's not arguing there's some freestanding, explicit constitutional or statutory right not to have the revocation proceeding go forward.
What about the analogy that Mr. Farley made that after conviction, after someone has served their sentence, there are similar concerns to something like double jeopardy? You know, he's making an analogy to that. What would you say to that argument?
So I mean, he to be clear, he has not served his written sentence, right? His written sentence is supervised release. So he is instead trying to alter the terms of his written sentence, which none of the cases that he is citing deal with. He was not sentenced to probation, immediate probation. He was sentenced to suspended probation. And so he has not served his supervised release plus his incarceration, which is where the cases that he's citing would come up potentially.
Okay.
No things.
Any further questions, Judge Randolph?
No.
Judge Walker? Okay, thank
Yes.
you. Thank you, Mr. Hansford. Mr. Farley, we'll give you 2 minutes for rebuttal.
Thank you. I'll begin with the government's reliance on Justice Scalia's opinion in Midland Asphalt. Justice Scalia's dissent in Sell, the later in time case, points out that what he tried to establish in his opinion in Midland Asphalt is no longer the case. Interlocutory jurisdiction is appropriate not only when there's a specific right that can be pointed to, but when there are analogous things that you can point to. And that is shown in district courts sometimes exercising interlocutory jurisdiction in criminal cases, and recognizing that there is some flexibility there. As for Judge Walker's questions about whether or not Mr. Rodas could be sentenced to a more strict sentence, I agree with the conversation that Mr. Rodas is not seeking resentencing, and we argue that that is not a possibility here. But if he is, if there is a resentencing involved, Mr. Rodas cannot be sentenced to a greater sentence because he has a legitimate expectation of finality in his sentence. Little 2 relies, I think, almost entirely on the fact that Mr. Little appealed his sentence under a direct appeal to show that he didn't have a legitimate expectation of finality. That is not the posture here. Mr. Rodas has that expectation, and his sentence cannot be increased. That's Townsend. That's North Carolina versus Pierce, as Judge Randolph pointed out. I think my last point would be that, as Judge Walker asked, if Mr. Rodas had filed this motion one day before the petition, potentially in a one-line motion like you proposed, there would be no argument that there couldn't be jurisdiction on appeal, and none of the cases pointed out by the government say why.
He did make the argument. Mr. Hansford made the argument.
Mr. Hansford said that response was that not in the cases where there is ongoing revocation proceedings. Your
hypothetical is not that.
Yes, I was saying if he had filed it one day before the petition was filed, then there would be jurisdiction on appeal here. And the unpublished cases in the Fourth Circuit don't explain why probation filing a petition would divest this court of appellate jurisdiction, one of which explicitly points out that the district court hadn't actually ruled on the motions yet. And so appellate jurisdiction was inappropriate. And so those cases should not control here.
And you might be right about Little not being analogous and the remedy that you would get if you win, either with this panel or if there's no jurisdiction here, a future panel. But sometimes our best guesses are not right.
That's correct. And that obviously we don't ask courts to speculate on future things.
Thank you very much. Thank you to both counsel.
Case number 25-5133. Vertex Pharmaceuticals Incorporated Appellant versus United States Department of Health and Human Services et al. Mr. Hallward Dreemeyer for the appellant, Mr. Winnick for the appellees.
Morning.
Good morning. May it please the court, Doug Hallward Dreemeyer on behalf of Appellant Vertex. I'd like to reserve 2 minutes of my time for rebuttal. The district court recognized that the purpose of the AKS is to prevent the providing or purchasing of healthcare services that are medically inappropriate in exchange for financial rewards. The government doesn't disagree with that. It actually quoted the same language in its brief. And in another case in the First Circuit, the same government counsel was even more candid. It said that the point of the AKS is that financial conflicts in and of themselves corrupt medical decision-making. But if this court agrees with those characterizations of the AKS, then it has to set aside the OIG's advisory opinion here, because OIG rejected the notion that the AKS requires anything inappropriate or corrupting. Mere influence over medical decision-making is a crime under the analysis OIG applied. OIG's construction cannot be squared with the text of the AKS, and that's where I want to start. The AKS starts in paragraph B1 by criminalizing the solicitation or acceptance of remuneration, including any kickback, bribe, or rebate, in return for providing, purchasing, or referring medically, federally reimbursed healthcare. Paragraph B2, which is the provision at issue here, is the flip side of the same coin. Congress criminalized offering or paying, quote, remuneration, including any kickback, bribe, or rebate, to induce such a referral or purchase. In other words, soliciting an unlawful referral or purchase in violation of B1. B2 and B1 operate as a complete whole. And Congress's use of the trio of examples, kickback, bribe, or rebate in both provisions, and its phrase remuneration to induce, which is the obverse of in return for in B1, confirm that AKS's two prohibitions operate together to prohibit both sides of a corrupt transaction that distorts medical decision-making from the medical merits.
Can I ask a hypothetical that's been on my mind? So if Vertex let's assume that the cost of the gene therapy is $1 million, and let's assume that the cost of fertility treatment is $70,000. If Vertex had just reduced the cost of the gene therapy by $70,000, it means that the government, through Medicare, Medicaid, would pay $70,000 less dollars. So that'd be a win for the government. Wouldn't necessarily be a win for the patient, though, because the government doesn't cover fertility treatments. So that would be $70,000 out of pocket for the patient. And the patient's not actually getting a personal, out-of-pocket discount on the gene therapy because the patient's not paying for that. The government's paying for that. So that might have been okay to do, but it wouldn't have helped the patient's pocketbook. So I think what Vertex did is they said, well, we'll charge $1 million for the gene therapy and we'll give you $70,000 cash for the fertility treatment. The problem is that the government has made a choice that it doesn't want to fund fertility treatments. So what you've in effect done is gotten the government's $1 million for the gene therapy, and then taken $70,000 of that paid for the fertility treatment. In other words, you have arranged the system so that the government will pay for the fertility treatment instead of the patient paying for it out of pocket. Because even though you're the one that's giving the $70,000, you're getting that $70,000 from the $1 million that you get from the government. So this seems like almost exactly what the anti-kickback statute is designed to prevent. You're making the government pay for stuff the government doesn't want to pay for.
No, Your Honor, because the government will pay its share of the $1 million, whether the patient gets fertility services or not. The government has agreed through the terms of the Medicare, Medicaid programs, what share it's going to provide. And that's true again here, whether or not a patient gets fertility services. Vertex is offering that from the money that it would otherwise have in order to assist patients to have access to this life-changing cure. And I think what OIG did in analyzing this was to assume that any influence on decision-making was enough to violate the statute. If what Your Honor's question implies is that there is something improper about Vertex's influence, some wrongful influence, that is the standard that the Ninth Circuit applied in Shana, the Fifth Circuit applied in Marchetti, the Seventh Circuit applied in Sorensen, but it's not the standard that OIG applied here. OIG rejected the notion that there had to be anything improper. They thought any kind of influence would be enough. And that's why OIG's construction captures merely engaging in a contract with an advertising agency, which is, of course, paid remuneration to recommend the purchase of a product. And that's the situation that's been addressed in Marchetti and Sorensen and Shana. And those courts recognize that it can't merely be influence. It has to be in some fashion wrongful influence in order to violate the statute. But that's not the standard that OIG applied here. Of course, we're on APA review, and so the proper thing for this.
Let me go back to and maybe I'll get the numbers wrong. We'll see. But take two patients. One gets fertility treatment, one doesn't. They both get the gene therapy. The government pays $1 million for each gene therapy. And under your program, both patients pay nothing beyond that. The first patient pays nothing for the fertility treatment because he doesn't get the fertility treatment. The second patient pays nothing for the fertility treatment because Vertex is paying the $70,000 for the fertility treatment. So the government in the first case is paying $1 million for a patient who's getting just the gene therapy. But the government in the second case is still paying $1 million for a patient who's getting the gene therapy plus the fertility treatment. So the government is in effect, for that second patient, paying for the fertility treatment.
No, they're getting more without having to pay for it. The Vertex is providing the fertility care. And I think that the CMS
couldn't Vertex just knock $70,000 off the cost of its gene therapy?
No, because Your Honor's question, your initial question is exactly right. That this is not something that Vertex can address by lowering the price, because that doesn't address the access to care problem.
Well, I'm not saying they could knock off $70,000 for all patients, but they could knock off $70,000 for the patients who need fertility treatment. And then the government would only be paying $930,000 for that patient.
And patients would still not get fertility treatment. That the system doesn't allow it, in a sense, because the government.
They could still get the fertility treatment. You could pay them $70,000 in that situation, and they would get free fertility treatment. The problem with that for you is you'd be paying them $70,000 out of the $930,000 that you get from the government, and you want to pay them $70,000 from the $1 million you get from the government.
But Your Honor, none of this is part of the OIG analysis, because OIG doesn't require that there be anything wrongful, anything about making the service more expensive to the government. Here, Vertex's product is $1 million less than the competitor product that was on the market. That was reflected in OIG's opinion. So this is not about causing the government to spend more for Vertex's product. If anything,
but it would be $1 million, and it would be $1,070,000 less than the competitor's product.
And
Vertex weren't kicking in the $70,000 to pay for the fertility treatment for the patients who want the fertility treatment.
But even that program that Your Honor hypothesizes would violate the criminal statute under OIG's standard, because OIG standard is anything of value that could merely influence decision-making, including in order to promote access to care. Eliminating a barrier to care is an influence that OIG says violates this criminal statute. And that is not consistent with what the Supreme Court said in Hansen when it construed induce not as mere influence. It explicitly rejected the notion that induce in a criminal statute means mere influence. It has to mean criminal solicitation.
Mr. Howard Dreamer, I mean, here the statute doesn't directly prohibit inducement. It talks about paying remuneration, that essentially causes a person to use more federally paid for healthcare or services.
It doesn't say causes. It
doesn't say causes. It's true.
It uses that trio of examples, kickback, bribe, or rebate, to indicate that induce does carry its traditional common law meaning.
So I find your interpretation intuitively very appealing, right? That this is a criminal statute, and so induce needs to have some kind of wrongdoing aspect connected to it. I understand that argument, but then this statute is written so broadly in a way that suggests that basically any remuneration, including rebates, there's nothing insidious about a rebate, that induces a person, to
Your Honor, rebate in this instance has a particular meaning because that trio of words, kickback, bribe, or rebate, come from the predecessor to the AKS. Before the AKS was amended in 1977, its predecessor statute in 1972 prohibited the offer, solicitation, or receipt of one, a kickback or bribe in connection with the federally funded care, or a rebate of a fee or charge for referring a patient. So that phrase, rebate of the charge or fee for referring, is a form of kickback. It's not just to the person who otherwise paid, it's to the third party who referred. So it's that same corrupt.
Right, but Congress has continued to broaden the statute. And I don't understand Vertex to be making any non-delegation argument, which
we're not, Your Honor. We're arguing that, but it didn't broaden it as much as it did in the civil statute. In the civil statute, Congress did use the word influence, likely to influence, but it omitted that trio of corrupt examples, kickback, bribe, or rebate, and it added other limitations. For example, the civil statute does not apply to the recipient, to the beneficiary, the patient. The civil statute does not apply to remuneration offered to promote access to care. The civil statute only applies when it is likely to influence the choice of a particular provider. All of those limitations are necessary precisely because Congress used this broader word to influence. In the criminal statute, it used a traditional criminal word, induce, that has a longstanding meaning of criminal solicitation. And in B2, the criminal solicitation is the violation of B1, which is that corrupt transaction that the government itself has characterized in other briefs. Corruption is at the heart of the AKS, but OIG reads it out. And that's why an advertising agreement would be violative under OIG standard. It's why a generous aunt giving her niece money to be able to overcome the financial barrier to getting the care she needs would be a crime. The government cannot defend the incredible breadth and really the absurd breadth of its reading. Most importantly, it can't explain why the criminal statute would criminalize precisely that conduct that Congress carved out even from civil liability in the access to care exception to the civil statute. You need that exception to the civil statute precisely because the civil statute uses the broader influence. But if the criminal statute only prohibits inducement, the solicitation of a crime, the solicitation of someone who's going to purchase the service in return for the money. A patient here is not purchasing Casgevy in return for fertility services. Fertility services merely address an unfortunate side effect of the conditioning necessary for Casgevy. Casgevy saves lives, Your Honor. Patients are not buying it. It's not medically inappropriate. And under all of the limitations of Vertex's program, it's designed entirely to make sure that the patient has been diagnosed with sickle cell or TDT, that the patient has already been determined to be appropriate for this product. It's not being advertised to the patient or anybody else. All of these are designed to ensure that the medical decision-making is not being corrupted. If the government thought, if OIG thought that there was some problem with Vertex's proposal, that there was something else that Vertex should do in order to make sure that it was not corrupting the decision-making, it could have asked Vertex about that. But it never got to that because under OIG's reading, categorically, anything that influences decision-making, or in the case of advertising, anything that induces one to recommend the purchase.
Okay, let me ask you a question. So if this court were to conclude that you succeed on your arbitrary and capricious challenge, right, to whether there was insufficient data to determine whether the program fits under the promotes access to care exemption. So if Vertex were to prevail on that, that doesn't really give you the relief you want under the kickback statute. I mean, is there any carryover effect?
Well, Your Honor, I think that it's exemplary of why the reading of the kickback statute is overbroad. Because again, as I said, under the government's reading, something that would satisfy the access to care provision, as CMS has determined, this is essential to overcome barriers to accessing this life-changing treatment, that would nonetheless be criminal. You couldn't do what the exemption under the civil statute, the CMPL, really invites providers to do, offer remuneration to overcome barriers to care, because you would still be committing the crime.
Do you think that HHS would have to revise its opinion about the criminal statute if it revised its opinion on the civil statute and whether Vertex fit within the exemption?
Well, Your Honor, I think that it would at the very least have to redo that analysis. I think that our argument that their construction of the AKS is one that would effectively prohibit companies from doing exactly what Congress encourages them to do in the exception to the civil statute. At the very least, I think OIG would have to redo that analysis. And I think that they would also have to redo their analysis in light of the three decisions in the last 2 years from the Ninth Circuit, the Seventh Circuit, and the Fifth Circuit, all of which say that induce in this statute means wrongful influence, not mere influence.
Can I also ask you a question about your standing on the timing regulations? So you're challenging the timing regulations, and now they've issued the opinion. So the challenge to the timing regulations isn't live in this case. But I don't see Vertex to make a capable of repetition yet evading review type of argument.
It's not in so many terms, Your Honor, but in order for the issuance of the opinion to moot our argument, this court's cases suggest that we have to have somehow said, this is a one and done for us. The opposite is true on the evidence here. Vertex has submitted multiple requests for advisory opinion. Vertex has indicated that as an innovator in this field, it will seek other advisory opinions. This is what Vertex does, change patients' lives. But it can't do that if every time it tries to assist patients to access their life-saving care, OIG is going to say, This is a crime. We have to, in fact, OIG's analysis here makes it even more likely that Vertex will have to seek advisory opinions, because under OIG's construction, everything that a pharmaceutical company does is a potential violation of the AKS. And so you have to go to OIG hat in hand, asking for its blessing to do something. That is not how criminal law works.
If I may interrupt you, I mean, there's a hidden problem here with the issue as posed, and it's one that has bothered me for quite some time, and it depends on how you frame up the question, whether you frame it as standing or whether you frame it as mootness. If you frame it as standing, you've got a problem, because the injury has to be imminent. And it doesn't seem to me that you've really established any imminent injury, maybe something in the future. But if you frame it up as a mootness question that's capable of repetition but evading review, there's no time limit on that. And it could be capable of repetition in the next 5 years, for that matter. And there's Supreme Court cases indicating that. So there's a conflict in the Supreme Court jurisprudence here. And I'm not really sure how intellectually you decide which is the proper framework, mootness or standing.
Your Honor, I think that the same analysis should apply to both of those elements of justiciability. Because what we have here in the case of OIG is a statute in which Congress has explicitly mandated that OIG's regulations shall provide that the advisory opinion shall issue within 60 days of receipt of the request. But OIG routinely delays, as it did here, a year. In the Pfizer case, as in this case, the opinion did not issue until after the requesting party waited a year for a decision, and then, unable to wait any longer, sued OIG, and only then did OIG issue its advisory opinion. This is a problem that is going to repeat over and over and over again, because every time OIG is sued, once the party has finally reached the breaking point, OIG will simply issue its opinion. Over and over again, it waits a year to issue its opinions because it does not regard the 60-day statutory deadline that Congress imposed as somehow binding on it. It is that disregard for the law. It's that view of OIG that it is the one that dispenses justice. It will decide when one can or cannot offer assistance to patients. That is not how criminal law works in this country. The Supreme Court has made clear in Skilling and McDonald, in any number of cases, that we do not depend on the grace of government. Criminal statutes are construed narrowly precisely so that parties can go forward in their normal operations without worry, and you don't have to go to the government to ask forgiveness.
Can I ask you, have there been successful prosecutions of pharmaceutical companies for this type of plausibly, non-corrupt rebate?
Yes.
I'm just wondering if they have been prosecuting companies for a similar type of scheme.
So, Your Honor, you use the word prosecute, but I think it's really important to underscore here that a violation of the anti-kickback statute is a per se basis for a liability under the False Claims Act. And so relators repeatedly bring False Claims Act cases on the basis of a purported violation of the anti-kickback statute. They prefer that theory because it relieves them of any need to prove individual causation, or so they think. And so they rely on the anti-kickback statute. And the government has collected billions of dollars on the basis of purported AKS violations, including patient support programs. The First Circuit brief that I referenced.
And those are usually brought by private relators.
And then the government comes in to support, because the First Circuit case that I mentioned earlier, in which the government said, of course, an AKS violation is a basis for treble damages under the False Claims Act. They said because an AKS violation means that there's been a financial conflict that inherently corrupted medical decision-making. That's what a brief written by Mr. Winnick in the First Circuit argued in order to establish treble damages under the False Claims Act on the basis of an AKS violation. That notion of inherent corruption, however, is absolutely missing from what the government thinks actually violates the AKS. And we think it's that interplay of the AKS, both with the civil monetary penalty statute, but also the False Claims Act. It makes sense that if it is a truly corrupt transaction that gives rise to AKS liability, that an AKS violation should give rise to treble damages because the claim would be false. But on the government's theory, the claim does not have to have impacted actual medical decision making. It doesn't have to be inappropriate medical care in any way for there to be an AKS violation. And that's exactly the problem, Your Honor.
Okay.
Can I, do you know when the next advisory opinion request will be?
From Vertex, Your Honor, I would think that it would be in connection with one or another of the new programs, new products that Vertex has that we're expecting FDA approval. Vertex has a number of products in development, and when it comes on, they will then see what are the obstacles to patients being able to obtain this care. In the case of Casgevy, there were two obstacles. One is the one we've been talking about today, which was infertility and the need for fertility preservation services. The other was that Casgevy can only be provided at particular treatment centers because it's a very, very specialized treatment. And so patients will often be unable to accept that because they can't get to the necessary hospital centers. And so Vertex also sought an OIG advisory opinion that merely offering transportation support to patients would not violate the AKS. Of course, OIG opined in that instance that, as with everything, it would implicate the AKS because it would be remuneration that was likely to influence patients' decisions to access the care. So it's a crime. Offering transportation to the hospital is a crime, but in that instance, OIG exercised its grace and said they would forgive the crime. But that, as I said before, is not how criminal statutes are supposed to work in this country. We don't go hand in hand to the.
I take that point on the delay issue. I suppose this wouldn't matter for standing or mootness, but if you do get to the merits, it seems like the delays happen when OIG asks for more information. I suppose within the 60 days, OIG could just deny write a letter saying we deny it because we don't have enough information, instead of giving you the opportunity to provide more information before they deny it.
I think that's quite possible, but note here, Your Honor.
How would you be better off in that regime?
Well, note here, Your Honor, that the lengthiest part of the delay here was from February, when OIG had already provided its oral determination that it was going to find that this implicates the AKS, and Vertex said, please write that up so that we can seek judicial review. That was in early February. OIG did not issue this opinion until July, after Vertex had already sued. That's in and of itself, that's more than 60 days. Now, how does OIG justify that delay? Because they said, well, we're consulting experts. That's another tolling provision that it has given itself, even though Congress did not give it. In fact, Congress contemplated in the statute that OIG would be consulting with the Attorney General, and yet in the same statute said that they have to issue their advisory opinions within 60 days.
That's a strong point. If we were to vacate based on the letter being unreasonably explained, what relief would you be seeking with regard to the delay issue?
I think with regard to the delay, the relief would be to declare that the regulation is inconsistent with law to the extent that it claims for OIG a unilateral authority to toll the 60-day period that Congress has set for it. I
And
think,
and your representation is that Vertex has new drugs that are in the FDA pipeline for which you would consider similar
Yes.
types of
yes, Your Honor.
remuneration. And so that brings it within
Yes, Your Honor.
that makes it an injury in fact.
Yes, Your Honor.
One last question, just go back to the merits. The government makes a lot of surplusage arguments. Under your interpretation of the statute, sorry, let me correct that. Under the government's interpretation of the statute, would it create any superfluidity?
Yes, Your Honor. I think it creates two different forms of superfluity. One, I think that the exemplary parenthetical of kickback, bribe, or rebate becomes superfluous. We think that that's informative of what is meant by remuneration to induce or remuneration in return for. That's that quid pro quo. The government's construction also creates what I think is a superfluity in the exception to civil liability, because no one would ever undertake the very thing Congress has encouraged companies to do, promoting access to care, under the civil exception, if they're nonetheless going to be criminal. As we say in our brief, Congress should not be understood to have made felons of the people who are doing exactly what Congress asked them to do in the exception to the civil statute. And I don't think that the exceptions to the AKS are superfluous, because we can all imagine, for example, the government uses the example of the exception for employment agreements. And we can all imagine situations in which an employee is recommending for purchase a product of his employer because he is receiving a salary from that person. That is his job to do. Even if he took his employee hat off, he might think that the best medically appropriate product would be another one. And
I saw that in the briefing. I think again, there's some, they have some strong points. You have some strong points. I'm not totally persuaded by the parenthetical point you made about surplusage, because the government's reading would make the words following including surplusage, which words are always surplusage when they follow the word including. Your reading would make the words following excluding surplusage, and usually words that follow excluding are not at all surplusage.
Well,
they're quite important because they
Your
change.
Honor, we gave in the brief the example of the mission products or technology case from the Supreme Court, and I happen to argue that case, so I am very well familiar with it. And I was arguing the opposite. I was arguing that all of these exceptions that only make sense if one presumes that a bankruptcy being a deemed breach does not make the contract disappear, because all of the exceptions were about how the counterparty to leases and other contracts would, in particular circumstances, retain their rights under those leases or contracts. And we said those would all be surplusage if a breach was not deemed to basically terminate the contract otherwise, but instead only provide the plaintiff with a cause of action for damages. And Justice Kagan, in her opinion, said, yeah, maybe, but these exceptions were all adopted over a long period of time just to make sure, for Congress to make sure that these things would not be a problem. That's the same thing here. None of these were not a long list of exceptions all adopted at the same time. They were adopted, I think, at like 9 different times over a period of I think it's something like 20 or 30 years. And there is not a coherent theme to them. And I think that the employee example is the perfect one. Of course, there can be employees who are making recommendations or referrals solely because they are receiving a paycheck that is corrupting, arguably, and would otherwise violate the AKS. But it's not surplusage, because Congress wanted to make clear that just categorically, those are off the books, right? Now, with respect to an advertising agency or other intermediary, that could violate the statute because we don't have an exception. And so the courts, when confronted with those examples, have said that it has to be somehow wrongful influence, because of course you're hiring an advertising agency to influence referrals or recommendations, right? And the generous aunt is another example. Of course, the generous aunt isn't committing a crime, and the government's only answered that is, well, the generous aunt doesn't want a particular product. Well, the word particular is not in the AKS. It is a limitation on the civil statute because the civil statute uses influence. But moreover, even if the generous aunt did only offer the assistance if the niece was going to choose a particular product, that still shouldn't be a crime. And the government's only other answer is to say, well, they wouldn't have acted willfully. But if the generous aunt is a lawyer, a judge, a doctor, anybody in the healthcare life sciences industry that knows about the AKS, they would be acting willfully. Thank you.
Let me see if my colleagues have any other questions. Judge Randolph?
No, I'm fine.
Okay. Judge Walker? Yeah. Okay. Thank you. We'll hear from the government.
Good morning, Your Honor. May it please the court, Daniel Winnick for the government. Before diving into the bulk of the arguments, I want to make sure I respond to 2 points you heard repeatedly from my friend on the other side this morning. First, the idea that we've argued in the past for some sort of separate corruption requirement, and second, the dichotomy between what he's called the civil and the criminal statutes. So on the corruption point first, it's just not right that we have previously characterized the AKS as suggesting there's some separate corruption requirement. The point of the AKS is that when remuneration is offered or given with the purpose of inducing medical decisions, that creates a financial conflict that inherently corrupts the integrity of medical decision-making and federal healthcare programs. The financial conflict is itself the corruption, and this is a case in point. Vertex would offer $70,000 worth of fertility services to patients in an effort to get them to use Vertex's product, Casgevy, as opposed to one of the competing products, as opposed to a different treatment, stem cell transplantation. Nobody is remotely suggesting that patients who do not need one of these arduous treatments for one of the terrible diseases in question is going to go through the treatment just to get the fertility benefit. Nobody's suggesting that, but the problem is when patients are choosing among treatments or between a cell and gene therapy and a stem cell transplant therapy, this $70,000 benefit creates a financial conflict of interest that may lead them not to make the choice that would otherwise be deemed by them and their doctors to be in their best interest. That is the corruption that the AKS exists to prevent. Second, on this civil and criminal point, you've repeatedly heard the BIS described as the civil counterpart to the AKS. That just is not correct. If you open the statutory addendum that accompanied Vertex's brief to page 29, you will see beginning on that page the entire civil monetary penalties law, 1320A7A. Okay, that goes on for pages. And if you go to page 31, you'll see 2 distinct paragraphs. One, subparagraph A5, that's the BIS. The second, subparagraph A7, allows HHS to impose monetary penalties for anybody who commits an AKS violation. So that one, B7, that's the civil counterpart to the AKS, not the BIS. The BIS is a distinct provision. It serves a related function, but it is not true. It is categorically not true that something that is accepted from BIS liability by the promotes access to care exception is accepted from all civil liability for AKS violations. The principal basis of civil monetary penalties for AKS violations is in subparagraph 7. That's the one that says you get a civil monetary penalty for conduct that violates the AKS. So this whole business of there's an absurdity because it's civilly protected but not criminally protected, that's just not right.
Mr. Winnick, can I ask you maybe a related question to that point, which is if HHS were to find that a certain program fit within the promotes access to care exemption, are there cases in which that exemption would apply, but the government would go after some company for criminal violations of the anti-kickback statute?
So I don't know.
I understand that they're not directly parallel, right? But there is, if the government were to conclude that it was within the exemption, wouldn't that have some consequence for how they exercise their prosecutorial discretion under the kickback statute?
I'm sure it would both in terms of criminal prosecutorial discretion and in terms of the discretion that HHS OIG exercises at the sort of second step of the advisory opinion decision-making process. So the first step is, do we think this would constitute remuneration to induce within the meaning of the
Right.
AKS? The second step is, even if we think it does, do we think the risks here are sufficiently low that we're going to exercise discretion to say, we'll forbear enforcement, we'll make you that guarantee, we'll issue a positive advisory opinion. I'm sure it would influence that, but as a legal matter, the promotes access to care exception does not apply to the AKS. It does not apply to civil monetary penalties for AKS violations under subsection, under paragraph 7 of the civil monetary penalties law. It applies only to the BIS. I'm happy to dive with that into sort of the principle.
Can I ask about the arbitrary and capricious challenge to the advisory letter?
Yes.
The advisory letter in footnote 13 cites this 2002 special advisory bulletin, and it says categorical financial need is not a sufficient basis for permitting valuable gifts. And I can see how, if that's true, your advisory letter here kind of flows from that and maybe makes sense. But I guess I'm not sure I understand. I mean, if people have a limited amount of money and you make something cheaper, it seems like you're increasing access to that thing.
Yeah, I don't think that the advisory opinion is saying anything to the contrary. I think what it is saying, and I don't have the bullet in front of me, but I do have the opinion in front of me. I think what it is saying is just that there's no general exception to BIS liability for like offering remuneration to people who are in financial need. I agree that if some program is actually serving the purpose of making it easier for people to get a treatment, an item or service, that would, generally speaking, increase access to it. The principal point of HHS's reasoning here on the promotes access to care exception was that mitigating a side effect of a drug is not actually the sort of thing you would usually think of as increasing access. So if I say, do you have access to Ozempic? What I mean is, can you get a doctor to prescribe it? Do you qualify for it? Can you get it from a pharmacy? Will your insurance cover it, or can you pay for it? I don't mean like, is there some side effect of it that might cause you to choose not to use it? And so here it is.
I'm not sure why, because let's take that example. It seems like a person deciding whether to purchase that drug would weigh all the benefits and would weigh all the costs. Those costs would include everything you just said. They would also include the side effect. And if you
So-
take away one of those costs, i.e. the side effect, it seems like you are, at least on the margins, increasing access.
So I agree that they would certainly take that into consideration in deciding whether to use the drug, but I don't think that's what access means. Both in terms of sort of plain usage and in terms of the regulations that define it here. Access refers to the ability of a patient to get an item or service. So the relevant reg that has the definition is 1003.110 subparagraph 6. It says improve a beneficiary's ability to obtain items or services. So if you make something more appealing by mitigating a side effect, by giving somebody.
What do you think? I mean, let's say that the only pharmacy where a drug exists has like a moat with sharks around it, and you're destined to, perish in the moat if you try to access the drug. And then along comes someone and eliminates the moat.
Yeah.
I think you would have increased access, right? So
Absolutely.
why wouldn't we view a side effect as, look, maybe the side effect is fatal. And then if you eliminate that side effect, just like eliminating the moat, you've eliminated an obstacle to the care, so you've increased access to the care.
I've lost your audio for a second. Can you hear me?
I can hear you. Can you hear me now? I think Mr. Wittick may have frozen, but it could be on my end.
It was on my end for a second. I think I'm back.
Well, I guess
You
my
still have
follow-up is,
access
why
to
wouldn't we
the
view a version of it is, why wouldn't we view infertility as the moat? For some people, that's just a cost they're unwilling to bear.
It is a cost they're unwilling to bear, but I think just like any other side effect of a drug that some people can choose to bear and some others might choose not to bear. It isn't an issue of access, but I don't want to get too hung up on this point because I think really the salient point about the BIS and about this arbitrary and capricious issue is the one Judge Rao asked earlier. I am not going to fight you hard on if you want to vacate the judgment in our favor in part and send this back to the district court to remand to the agency for it to better explain its application of the promotes access to care exception. The more important point is that would have absolutely no effect on the bulk of the reasoning in the advisory opinion. It has absolutely nothing to do with HHS's judgment as to whether this violates the.
You wouldn't have to reach that, right?
I suppose you wouldn't have to reach it in the sense that Vertex doesn't get what it wants unless they have a favorable advisory opinion in hand. And so I suppose even if you said, well, the whole thing sort of goes back to the agency can look at the whole thing, that sort of doesn't get them the relief they're looking for.
I mean, Mr. Winnick, you said earlier that if the agency were to reach a different result on the promotes access to care exception, that they might then need to revisit whether they would excuse this. If it fits within the AKS, there might be a reason to, withhold prosecution.
I think
threat of prosecution.
Yeah, I mean, the point I would make about this opinion is they thought about all of these issues in deciding whether to exercise their discretion the first time.
Well, they didn't though, because
about
they didn't decide the promotes access to care exception. They said we don't have enough data. So if we think that's unreasonable, and if they concluded that the exception applied, then there might have to be a different decision on the kickback statute. You said that at the start of your argument.
Well, let me be clear. They might reconsider. They are always free to reconsider. Vertex could go back to them tomorrow and they could reconsider whether to exercise their discretion to forbear enforcement in the future. That's a Heckler versus Cheney classic, non-reviewable.
Of course, but you said that the promotes access to care reasoning, is connected to the forbearance of
the sort of reasoning. Yeah, the sort of reasoning that would lead the agency or the government to think that the promotes access to care exception applies is the same sort of considerations they might consider in deciding whether to forbear enforcement. The key point I need to make, though, is it doesn't have anything to do with the legal issue that is really the heart of this appeal, which is what does the phrase remuneration to induce in the anti-kickback statute mean? And so I think that is the issue of greatest forward-looking significance to the government. Vertex's arguments on that point would really decimate the AKS. They would render it essentially useless. And so if the court thinks the promotes access to care analysis is insufficiently explained, it could send the case back to the agency for the limited purpose of reevaluating that. And if the agency, in its discretion, wants to...
We wouldn't have to say for the limited purposes. I mean, at least as a formal matter, they've raised an APA challenge. The remedy is to set aside the agency action. We could provide the remedy they seek by setting it aside without opining on anything other than what required it to be set aside, correct?
I think that's probably right. This isn't a rule where you look at like severability for set aside the agency decision only in part. But my point is that it doesn't get them to where they ultimately want to go. I mean, the reason they are here arguing is that they think it is unlawful for OIG to say that the thing they are thinking of doing violates the anti-kickback statute because it provides remuneration for the purpose of inducing medical decisions. And that's categorically wrong. And if it were true, it would decimate the AKS. It would leave it essentially a husk of itself. So to turn to that point, can
you talk about the relationship between that argument and the False Claims Act, right? I mean, the False Claims Act inducement has to have, is interpreted differently from how you understand induce in this statute. But the anti-kickback statute it gives rise to False Claims Act lawsuits and liability. So how do we understand how those things fit together?
Sure. Let me try. So first, I want to make clear that the word induce in this statute is not talking about causation. It's talking about purpose or motive. So the phrase the statute uses is gives or offers remuneration to induce. And what that means is with the purpose of inducing. Okay. The False Claims Act, and this is complicated because there are a couple of ways in which an anti-kickback statute violation can render false a subsequent claim seeking reimbursement for the government. One of them, there's a federal statute that says a claim that includes items or services resulting from an anti-kickback statute violation is false. That was the provision that was disputed in the First Circuit case that my friend has mentioned. The government can also prove falsity where somebody falsely certifies compliance with the anti-kickback statute. So there's various causation issues that arise in the FCA context that are complicated, and I think not the one before this court. But in this statute, induce doesn't mean causation; it means motive or purpose. And so I'm happy to start there with whether the fertility treatments here would be given to induce choices by patients. Vertex relies essentially wholly on Hansen, but the Fourth Circuit correctly explained in its very recent decision in Pharmaceutical Coalition why Hansen is completely inapposite here. And the basic reason is that the statute in Hansen forbade the inducement of criminal conduct, in that case, unlawful entry into the United States. There's a lot of statutes that do that. 18 U.S.C. 2, for example, says whoever induces the commission of an offense against the United States is punishable as the principal, just like aiding and abetting. But the conduct that the AKS forbids trying to induce is not unlawful conduct. The conduct the AKS forbids trying to induce is medical decisions, right? The purchase or provision of medical care, referrals, those are, generally speaking, not unlawful. And so if you construe the AKS as violated only by offering or paying money for the purpose of soliciting or facilitating an unlawful act, which is what Vertex urges you to do, that's the language from page 27 of their brief, it would never be violated, right? There's essentially no circumstance in which somebody is going to be offering or giving remuneration for the purpose of soliciting or facilitating an unlawful act. Medical decisions are, generally speaking, lawful. Indeed, it's worse than that because the prior version of the AKS didn't use the remuneration to induce language. And everybody agrees that when Congress amended that statute in 1977, it was trying to broaden the statute. And so Vertex's argument would have you believe that when Congress acted in 1977 using language clearly meant to broaden the statute, it actually took a functional statute and rendered it useless. And this point you heard from Mr. Hallward-Driemeier this morning, that actually none of that is right because there's this parallel provision of the AKS, the solicits or receives provision, and therefore the thing you're trying to induce is criminal. That's incorrect for two separate reasons. First, the conduct that it is unlawful to try to induce under the gives or offers provision is not the solicitation or receipt of the remuneration. It's not the thing that violates the parallel provision, it's the medical care. That's not unlawful. That's not unlawful under the parallel provision. That's generally not unlawful under any provision. And second, even if you sort of understand their argument generously to be that there must be some violation of the solicitation or receipt provision whenever there's a violation of the gives or offers provision, that's also incorrect because the gives or offers provision is violated by an uncompleted offer, a rejected offer. And so if you offer somebody remuneration to induce a medical decision and they say no, the medical decision is completely lawful. And so this entire response to the core superfluity that their argument would create, which is that it would render the gives or offers provision meaningless, is just completely incorrect. It is built on a fundamentally atextual understanding of the statute. And even aside from that superfluity problem, the problem of rendering the entire provision useless, the whole scheme of statutory exceptions would be pointless under their understanding, right? You don't need an exception to say, to cover the bona fide payment of a salary to a doctor in a medical practice if they're correct about what induce means, right? If induce means only soliciting or facilitating an unlawful act, it's obviously not unlawful for a medical practice to be paying for a doctor to be providing medical services in return for a salary from a medical practice. The second basic reason Hansen is inapposite, which is closely related to the first, is the one, Judge Rao, you noted earlier, which is that the anti-kickback statute doesn't forbid inducement as the forbidden act. It forbids giving or offering remuneration. It uses the word induce only in describing the purpose with which it is unlawful to give or offer remuneration. There's lots of other statutes that use the word induce that way. We give a number of examples in our brief. Those would all likewise be rendered completely inoperative if the word induce were read as Vertex does. And so they sort of act as if we're resisting Hansen. We don't resist Hansen's basic point that when you see the word induce in a criminal statute, that is, as Hansen says, a clue that it might take a specialized criminal law meaning, but that's not the end of the analysis. It wasn't the end of the analysis in Hansen, and it's certainly not the end of the analysis here for all of the reasons the Fourth Circuit ably explained. On remuneration, I'm happy to answer any further questions the court has about to induce. But on remuneration, again, they don't dispute that $70,000 worth of fertility services is remuneration in the ordinary sense of the word. It is a payment of something going to patients, right? What they argue is that it should be given a meaning other than its ordinary meaning. And they make that argument on the basis of the Nascatur and Eustem canons, and I'll try to avoid Latin after that. And it's just completely textually unconvincing. So as to the Nascatur canon, they say, well, kickbacks, bribes, and rebates are all, corrupt, evil things, and therefore remuneration must also be understood in this limited way. But first of all, as one of your honors noted earlier, even if kickbacks and bribes are inherently corrupt, that's not true of a rebate. And second, even if it were, the statute doesn't say kickbacks, bribes, and rebates. It says any remuneration, including any kickback, bribe, or rebate. And as the Fourth Circuit explained, there are three different textual clues there that the meaning of remuneration is broader than the meaning of kickback, bribe, or rebate. There's any, there's including, and there's the parentheses. And this is not.
Do you have thoughts on Judge Randolph's question about standing and mootness?
Sure. So I don't perceive there to be a real difference here in terms of the logic of the doctrines. The district court sort of talked about this in terms of mootness. I think we agree with Vertex. It's probably better thought of as an issue of standing at the time they amended their complaint. So to remind you of the chronology here, they filed their initial complaint. It said, it's essentially like mandamus, issue me the opinion, and we challenge the regulations. And then 3 days later, OIG issues the opinion. They amend their complaint. And they say, we challenge the opinion and please invalidate the regulations. So you look at standing at the time of the amended complaint, that's black letter law, and there's nothing either alleged in the amended complaint and certainly nothing established with evidence at summary judgment that establishes a concrete forward-looking harm to them from the understanding of the statute that they.
And at the time of their original complaint, they did not ask the court to vacate their regulations.
They did in their original complaint, same as in the amended complaint.
Wait, they did or did not?
They did in the original complaint.
Mr. Winnick, let me just, if we assume for the purpose of this question that they do have standing to challenge the regulations, I mean, how are these regulations consistent with the statute? I mean, HHS has authority to make regulations about these advisory opinions, but then in a section that says specific contents, it says the secretary shall be required to issue to a party requesting an advisory opinion, no later than 60 days after the request is received.
It says that. It also says in a neighboring provision that the secretary should specify by regulation the procedure to be followed, including, quote, the interval in which the secretary shall respond. So there is certainly some play there.
Well, I mean, the play that they give that discretion, but then in a section that says specific contents, it says gives this 60-day deadline.
I think the best way to understand the regulations as wholly consistent with the 60-day timeline in the statute is that if you send the agency a piece of paper with a scrawled crayon drawing and you'd say, I'd like an advisory opinion, please, right? Any rational person receiving that is going to say, that's not a request. I haven't received a request for an advisory opinion. And I think in substance, what OIG has done here is to say, we have only received a request for an advisory opinion, thus starting the 60-day clock, when it actually contains the information we need to adjudicate the opinion. And if that weren't the case, there really is no way the statute would operate. Right here, OIG posed questions upon accepting this request for an advisory opinion. Vertex responded 3.5 months later, right? The gap from late June to mid-October 2023. And under their interpretation of the statute, OIG would have been compelled to respond with an advisory opinion 2 months into that time, before OIG had gotten the information it needed. So, maybe as Judge Walker suggested earlier, I suppose they could respond by saying, you've asked for an advisory opinion, right? We don't have what we need. We can't give you a favorable advisory opinion, so, denied. And then they would have to come back and pay the fee again and go through the whole process again. It is very difficult to see why anybody would be better off in that situation, which I assume is why no pharma company has raised this sort of challenge before. And that is, I think that's why the sort of perfectly sound reading of the statute is the one OIG has adopted, which is
Which
when
is we can take it 1 year to issue an advisory opinion that Congress says has to be issued in 60 days.
No, and I'm not going to defend here, and they're not challenging here because this part of it is certainly moot. The time that OIG took beyond the 60 days, even as told, that's clearly not within the contemplation of the statute. But what's being challenged here is the regulations that say we toll the 60 days when we don't have the information we need, either when we don't have it at the outset or when we've initially accepted the request and then we make a further request for information and it's outstanding. The requesting party hasn't responded. In that circumstance, the agency has not received a request that it can functionally act on. And so either you say, as they have, that it's told, and then somebody will get a real advisory opinion at the end of it, or you say, if there's no tolling, they'll just have to issue an opinion that says, we don't have enough information here to do anything, and it's unclear why.
Even if it's told while they're waiting for the applicant to provide more information, I mean, they still should only have a 60-day window, right?
As told, right? So once the information comes back,
and that doesn't seem to be what OIG is doing.
I will acknowledge that in this case, it took
what they have not done, at least in this case.
I will acknowledge that in this case, I don't know the general statistics, but in this case, it certainly took longer than the 60 days, even as told. I'm not defending that as.
So are you saying that what they did was inconsistent with I know you're basically conceding it's inconsistent with the statute. Are you also conceding it's inconsistent with the regulations?
It took longer here than either the statute or the regulations would allow, but any argument based on that is clearly moot. Vertex isn't making that argument. They are challenging the regulations themselves based on the idea that they have some forward-looking risk of harm. But they're really, I mean, it's quite clear, I think, under this court's precedents that they have not alleged the sort of concrete, non-speculative future risk that this court and the Supreme Court routinely require for standing, even in their complaint, which is the only thing they cite in their opening brief. First of all, complaint's not evidence, which you need at summary judgment. But even that, they just sort of say, we're a pharma company, we'll probably have advisory opinion requests in the future. That is exactly the sort of someday intention that, as Justice Scalia explained in Lujan, does not establish a concrete, non-speculative,
Why isn't this similar to some of our FOIA cases where we say repeat FOIA filers can challenge? And I understand these, there are not as many of these advisory opinions, but I think, there are only a handful of advisory opinions every year. Vertex is a company that's already sought several of the whatever dozen or 20 advisory opinions that are issued. They say they have, innovative drugs pending FDA approval for which they might use this. I mean, why isn't that sufficient here?
I think the comparison to the FOIA case law underscores quite clearly why we win here. So cause of action, which is the case they cite in their reply brief, in cause of action, the requester had multiple other FOIA requests pending at the time. Right? So
well, that's just the nature. I mean, in some sense, though, that's the nature of FOIA litigation. There are these organizations that they just send hundreds and thousands of FOIA requests. But I mean, this is it's a different type of, government service, arguably, right? I mean, no pharma company has, well, maybe some do, but, thousands of, drugs for which they are seeking an advisory opinion. That's just not the nature of this type of thing.
Let me put it this way, Your Honor. If it were easy and obvious that, of course, they're going to have future advisory opinion requests, it would not have been difficult to do what this court's case law and the Supreme Court's case law clearly require, which is for them to say, in a complaint and then in a declaration, we generally do 2 of these a year, right? So I anticipate we'll do 2 in the next year. Or we have a drug under development that we think we're considering a program like this, and we anticipate submitting a request 8 months from now. There's nothing remotely like that, even this morning.
Is your argument that Vertex, based on the representations that it has made, in its reply brief and here at oral argument, that it lacks standing, or that they have failed to meet their burden of demonstrating standing? Because there is a little bit of a delta between those things.
So I would say it's even more clearly the second. They certainly haven't met their burden. Based on the representations this morning and in the reply brief, I'm not wholly sure they could, because I think Mr. Hallward-Driemeier was careful not to be too specific. And there's just nothing, either in what he said this morning or in the reply brief or in the opening brief or in the complaint, that is anything other than this sort of general, we'll probably do this in the future. And it's exactly the sort of thing that, as the Supreme Court said in Lujan, that sort of someday intention, absent any concrete specificity, absent even a
Mr. White, you
concept
might
of when
be
someday.
correct that our FOIA precedents are inconsistent with Lujan. That might be a problem for us for another day, but they are what they are. So why should we treat a pharmaceutical company worse than we treat a FOIA requester?
I am not aware of a FOIA precedent that would allow standing based on what you have here, just based on just the fact that you have an organization that routinely makes FOIA requests, and it'll probably make some in the future. Again, they've relied on cause of action. In cause of action, you actually had multiple other pending requests at the time. There is no need in that sort of situation to speculate about whether the requesting party is again going to be subject to the harm. There's nothing like this sort of we'll probably do it in the future. I'm not aware of a case, FOIA or otherwise, where the court has accepted that sort of theory of standing.
Okay.
Unless the court has further
Can
questions.
give you, if you're not aware of a case, I can give you one, and that's the KKK case. Is 972 Fed 2nd 365. It's not a FOIA case, but it's the same question about how much they have to show in terms of repeating the conduct that is now ceased. It's an opinion in our court.
Okay, I'm not familiar with it, Your Honor. I certainly believe it exists, but again, I think the general case law, both from this court and the Supreme Court, requires concrete specificity as to forward-looking harm, and there's just nothing like that here.
Well, I'm repeating myself, but that's only true when the issue is framed as standing. When the issue is framed as mootness, there are Supreme Court cases that do not require any showing other than what would be in a complaint.
So, I mean, here I think the comparison between standing and mootness really, again, just sort of underscores why the way Vertex is asking you to think about this is not really the right way to think about it. They sort of say, well, if we don't have standing, then like nobody can ever challenge these regs because the case will be brought and then OIG will issue the opinion. If that is a problem, there is a way to deal with it, which is the capable of repetition but evading review exception to mootness. You would say, is it clear that the same requesting party is going to be subjected to it again? And is the dispute one that by its nature is too short to, that it's not going to get resolved before the particular dispute has terminated? They haven't made any suggestion to that effect here. I think, again, that's clear because they waited months and months after the opinion supposedly became overdue on their interpretation to bring the suit. So there's no genuine problem here. If this dispute persists in the future, the court can resolve it then, but they clearly don't have, there isn't jurisdiction, whether for standing or for mootness reasons, to decide in this context.
Okay. Are there any further questions, Judge Randolph?
No.
Okay. Judge Walker?
I'm done.
Okay, thank you. Okay, well, Mr. Howard, Dreemeyer, 2 minutes for rebuttal.
Thank you, Your Honor. I note that Mr. Winnick did not address the reasoning of Sorensen, Marchetti, or Shana, each of which construed the very language we're discussing here as requiring not mere influence, but wrongful influence. Now, in their brief, they say that's different because that deals with advertising and middlemen, but the statute applies equally to recommending the purchase. That is quintessential advertising. And when faced with those facts and the breadth of the statute, Marchetti and Sorensen, who weren't applying Hansen, agreed that it must be wrongful influence, not mere influence, because otherwise it would outlaw advertising, and that makes no sense. But Hansen provides the answer, and that's what Shana relied on, because Hansen said not simply that it's a clue, but when Congress uses this word that has an established criminal law meaning, it presumably adopts that criminal law meaning. And here, that criminal law meaning is soliciting the crime. Now, here, the crime is the one defined in B1, which is purchasing the governmentally reimbursed product in return for the money. That is what one is trying to induce. We're trying to induce the purchase of the product in return for it. The money is being offered as the inducement. And so that is why in Sorensen, they specifically say, and this is at 134 F4, at page 502, the payment has to be made in order to induce unlawful referrals. And again, that was not even applying Hansen. That's just on the basis of the text of the statute itself and this relationship between B1 and B2. Hansen comes in and confirms that that is correct. And that's what the Ninth Circuit analyzed in Shana. That when you adopt the presumption, and the government never here says that they have overcome a presumption, they just want to ignore the presumption. They say Hansen's different because it was soliciting unlawful immigration. But here it's soliciting the purchase in return for the remuneration. That's the opposite of induce. And so they are on all fours.
Okay, I'll give you a few minutes, just not a few minutes, a few seconds to just wrap up. Yeah, please.
Well, Your Honor, I think that what the government's argument here, including its failure to address how the statute applies to advertising, to the generous, and the interplay between the civil statute and the AKS, which the Second Circuit and Hall, the Sixth Circuit and Martin have recognized are cousins with the AKS, shows that its reading is overbroad. What the government wants is for parties to come hat in hand asking for discretion on the government's part, but that's not how we construe criminal statutes in this country. Thank you, Your Honor.
Okay, thank you very much. Thank you to both counsel. The case is submitted.
Case number 25-1796. Venezuela U.S. SRL versus Bolivarian Republic of Venezuela appellant. Mr. Perla for the appellant, Mr. Conlon for the appellee.
You. Whenever you're ready, Mr. Furlan.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court. Juan Perla of Curtis Malay for the appellant, the Republic of Venezuela. This appeal presents a question that was left unanswered by this court in Valores, and that is whether recognizing and enforcing an award that is governed by the New York Convention violates U.S. public policy where the arbitral tribunal and the petitioners chose to deal only with the Maduro regime after it was derecognized by the United States and therefore lacked any authority to speak for or bind the Venezuelan state as a matter of U.S. law. Although it's a novel question, the principles that decided are centuries old. From the founding, it was understood that only the executive branch has the power to recognize the legitimate government of a
Mr. Perla, I know how important the recognition power is for Article 2, but I'm wondering, I mean, here, Venezuela didn't make any objection before the tribunal about the question of representation. So the arbitral tribunal, unlike in Valores, made no statement about which counsel was legitimate or whether they were representing the properly recognized government of Venezuela. There was no challenge at all. So how can, confirmation of the award here even implicate the recognition power? I mean, the award here doesn't say anything about the legitimate, government or the council representing the government.
Well, Your Honor, it first of all, the interim government, the recognized government, did not have an obligation to intervene at that point. It was not put on notice. As the district court here recognized, there are other jurisdictions outside of the United States that recognize the Maduro regime, and there was no way to anticipate that the U.S. would come to the U.S. to enforce this award. Also, there is an analogous situation in the Pemex case where it didn't matter what the foreign tribunal was purporting to do or thought they were doing. In that case, it was whether the Mexican court had retroactively applied the relevant statute. And the Second Circuit looked at that and said, in fact, the Mexican court said, we're not doing that. So it wasn't even silent. They were saying they disavowed that they were doing that. And the Second Circuit said, what we look at is the effect What is the effect of recognizing that foreign tribunal's judgment?
In Pemex, there's an actual legal effect. There's a disagreement about what the tribunal did, whether it was retroactive or not. So they can say it's not retroactive, but a U.S. court can look and see whether something's retroactive. Here, there's no consideration or adjudication at all by the arbitral tribunal because Venezuela, the interim government never made any kind of challenge before the tribunal.
Well, the recognition can be implicit, Your Honor. It doesn't have to be explicit. The tribunal doesn't have to say, we are choosing one over the other, or we are formally recognizing the Maduro regime. It is the conduct of allowing the Maduro regime to come in and speak on behalf of the state as if it were the legitimate government of the state that incurs the infringement of the recognition doctrine, because it would be inconsistent with the recognition of the National Assembly and its leadership.
Well, for the same reason that you just said, why would Venezuela challenge it? Because some countries recognize the Maduro regime. Why would the arbitral tribunal feel the need to question who was representing Venezuela if Venezuela made no challenge to it?
Well,
to the representation by the Maduro Council. The argument kind of goes both ways.
I don't think so, Your Honor, because the tribunal may be doing things that it thinks are consistent with laws that apply to it and that may apply in other jurisdictions. It's not necessarily looking proactively to make sure that its award will be enforceable as a matter of public policy in every single jurisdiction. Frankly, that would have been on VUS to alert the tribunal to the fact that there was a problem that for them might have consequences if they try to enforce the award in the United States. And that is
the United States is supposed to intervene in international arbitration involving commercial transactions between a company and another foreign country. Are you suggesting the U.S. government?
No, Your Honor.
That seems quite outlandish.
No, Your Honor, VUS, the petitioner.
Oh, VUS. Okay, thank
not
you.
The U.S. government.
Yeah.
So it would have been incumbent on VUS to alert the petitioner that there might have been a problem. In fact, VUS cites an example of Conoco. It's at JA 94. Conoco was arbitrating with Venezuela at the time that the recognition was affected, and Conoco allowed for both governments to participate. And then they brought their award to the U.S. They were concerned that if they brought the award to the U.S., it might confront a public policy challenge. So they made sure that they prevented that problem from arising because they anticipated potentially bringing it to the U.S., which they did. The U.S. did not do that here. So it was not a problem that the U.S. recognized government did not attempt to intervene in the arbitration, because that would have not been necessary if the award was not going to be enforced in the U.S. It also doesn't have any implications for purposes of waiver or forfeiture, because the public policy exception cannot be waived under this court's decision in
What did the arbitrators do, if anything, to acknowledge the receipt and consideration of filings by the council that purported to represent basically the council that replaced you?
They allowed it and welcomed it without giving us any notice of the purported attempt to change. We didn't receive any notice.
You say they allowed it, but this is a friendly question, I think, because I bet they did more than just passively remain silent. Did they say or write anything to suggest we are considering the filings by the new council?
Yes, Your Honor. What you mean is they didn't just allow the council to be changed. They then received submissions from the Maduro regime's representatives. They had an entire damages proceeding to determine what the amount of the liability would be. So all of those acts were undertaken by the arbitral tribunal, and the
proceeding was live. It was an oral argument,
I believe it was.
It was not just on paper.
That's correct, Your Honor. There was a proceeding, I believe, that dealt with the damages at a hearing. And it is taking that award, all of the things that the Maduro regime did, and bringing it into the United States and asking this court to convert what is otherwise a quasi-contractual private arrangement and give it the imprimatur of the court by converting it into a U.S. judgment, that would be inconsistent with the U.S. executive's recognition of only the National Assembly as being able to speak and bind the Republic. And that is what makes a New York Convention award significantly different from the LORAS, the ICSID award, because the ICSID award comes to the U.S. already as a U.S. state court judgment entitled to full faith and credit in the first
Was
instance.
Conoco an ICSID or New York?
Conoco was an ICSID award, I believe, where the issue arose. But I think that was before Valores. So I believe Conoco was probably cautiously avoiding any potential defect of litigating only with the Maduro regime that was derecognized by the United States, because they were going to come to the US and enforce the award. And so that would have been the appropriate thing for VUS to do in the arbitration if they intended to come here. And this is a significant infringement on the executive, but it's a matter of U.S. public policy because the recognition doctrine is meant to govern not just the government, but also the business transactions and commercial transactions that private parties enter into with the Venezuelan state during the time period in which the U.S. recognizes a different government than who may be purporting to be acting on behalf of the state outside of the United States. And that comes straight from the Supreme Court's decision in Guaranteed Trust, where they say, and I quote, "The very purpose of the recognition by our government is that our nationals may be conclusively advised with what governments they may safely carry on business transactions and who its representatives are." And then it goes on to say, quote, "Recognition would be but an idle ceremony yielding none of the advantages of established diplomatic relations in enabling business transactions to proceed if they didn't deal with the recognized legitimate government." So this is a matter that goes beyond just a formal acknowledgement of who the Venezuelan government is. It is meant to impact the way that we as a nation and the people here interact with that.
Do you think we would benefit from asking the Department of Justice if they have views about the public policy exception here, its applicability?
Specifically, the public policy, Your Honors, you're obviously welcome to ask the views of the U.S. government. I think we have everything we need from the U.S. government to make the determination here. We have very clear recognition, derecognition of Maduro, very clear recognition of the National Assembly. We have a public policy exception that allows for refusal of this award. And we have a long history of jurisprudence, constitutional provisions that elevate the recognition doctrine to the level of U.S. public policy, including Pink decision and others.
Mr. Perla, I mean, okay, even if we assume that, the recognition power is something that could implicate the public policy defense under the New York Convention, how would our confirmation of this award actually run afoul of the recognition power? So there's an award that says nothing about representation or, the legitimate counsel or the legitimate U.S. recognized government. How would our decision actually implicate that public policy? I mean, under the reasoning of Valores basically says it doesn't, in facts that are, more favorable in Valores than they are here.
Well, I'll take that in two parts, if I may, Your Honor, and I see I've run out of time. I think what Judge Walker was mentioning is significant, which is not only was there a swap of counsel that was recorded in the award, but there were submissions that were treated as if they had been submitted by the Venezuelan state. There were hearings that were held where the Maduro regime's representatives purported to speak for the Venezuelan state. All of that was factored into determining what the damages were, into deciding what liability the Venezuelan state would have, and it was done without the presence of the U.S. recognized government. And that is significant. The 11th Circuit, for example, in Lukoil, confronted the argument by the Maduro regime appointed a board of the national oil company, PDVSA, who said, just let us in because we have the same interests ultimately as the Guaido appointed board, so we can carry the water for the national oil company that is owned by Venezuela. And the 11th Circuit said no, because they may desire the same outcome, but the recognition that the US government has made requires us to not give you any authority, Maduro regime appointed board, and we would only be able to hear and give credit to the statements of the Guaido, or National Assembly recognized board. So I think that Judge Walker makes some very good points about that. And so the difference with Valores is that in Valores, the judgment or the ICSID award is already a judgment entitled to full faith and credit.
But
So
that was not the reasoning, and like the Valores reasoning. There was reasoning about the ICSID judgment, but then the discussion about the recognition power does not turn on the way ICSID works. It turns on the specific facts of the case and says nothing we would do here would be running, into the recognition power.
So I don't think that's quite right, Your Honor. The way I read Valores, it was focused very specifically on ICSID awards. It was very much focused on the uniqueness of the ICSID convention, how it is insulated and self-contained, how if the ICSID institution sees the award as binding, full faith and credit means that the US courts must also treat it as binding.
That was in the discussion in Valores about full faith and credit. And then the panel separately considered, even if there should be full faith and credit, does this, recognition power argument undermine, our decision to give it full faith and credit?
Well,
I'm interested in your thoughts on why that's not the right way to read the decision, but
I think it actually helps us, Your Honor, that the court in Valores analyzed first whether the award was entitled to full faith and credit as a state court judgment, and then said, yes, it is, and then said, therefore, we can't do anything more. And in fact, the court says, notes, there is no roving public policy exception to full faith and credit. So whatever implications might come of the U.S. recognition, it's not something that we can look at.
But the court also said that in enforcing the award, the court is not recognizing any regime as the current government of Venezuela. And if that's true, there's no contradiction between the recognition clause and the judicial enforcement and recognition of this award. And I don't know how you get around it.
Well, Your Honor, I don't think that it is that can be read outside the context of it being an ICSID award. In fact, both places where the court explained this very issue of not equivalent to recognition or not implicating the recognition power, it made very specific that it was referring to ICSID awards. And it makes sense to treat it that way because as the court analyzed, Congress implemented a statute that gave it full faith and credit and treated it as if it was already part of the U.S. legal system. The president ratified the ICSID convention and signed the implementing statute. So there was an agreement between the executive, between Congress, that when it dealt with ICSID awards, which are very special, which are very unique in terms of the way that they're structured under the convention, we would not be looking behind what the tribunal did because it's a self-contained system, and we would be treating it as if it were a final judgment of a state court that was already part of our legal structure. That is not what happens with the New York Convention Award, which is in the nature of a contract, as this court and the Supreme Court have observed. And it is the act of converting it into a judgment through the confirmation and enforcement process that you give it the judiciary's stamp of approval. And that is what incurs the implicit, if not explicit, contradiction between what the tribunal did in terms of allowing the Maduro regime to speak and act for the Venezuelan state, and the executive's recognition in the United States that Maduro is not the head of state. His acts cannot be given the legitimacy of being the recognized government, because then it would result in things like, is he entitled to immunity? Other things that might start to sound in the fact that there is a contradiction between what the tribunal did and what the executive.
Mr. Perley, but Venezuela is not bringing an inadequate representation defense here under the New York Convention. And I assume that's maybe because you can't demonstrate prejudice from adequate representation. So there's no, I mean, that is also another exception to the New York Convention is lack of adequate representation. But am I correct that Venezuela is not bringing such a challenge?
We haven't invoked,
not trying to get within that exception?
we haven't invoked that here, Your Honor, because the public policy exception is really the most relevant and applicable exception here. Again, under the public policy exception, if we're right that the recognition doctrine is a public policy, I think Lukoil is a very good, from the 11th Circuit, is very instructive on the point that it doesn't matter whether the interests and the advocacy may have been aligned and may have been adequately represented by the Maduro regime. What matters is that allowing the Maduro regime to speak for the Venezuelan state and then enforce that award as if it had been the Venezuelan state that had appeared and defended would be a contradiction of the executive's recognition power.
So,
and you have to.
Why doesn't accepting your argument allow nations to, play games with this, right? You kind of allow this to go forward, a large judgment issues against Venezuela, not challenged before the arbitral tribunal, and then you come to enforcement in the US courts, claim the public policy exception.
I'm really worried.
Again, Your Honor, I think it's because the New York Convention has more than, I believe, 190 government parties to it. So not all of them recognize the National Assembly. Many of them recognize the Maduro regime. So the U.S. could very well have a strategy where it's trying to enforce its award and litigate with the Maduro regime and has at its availability these other jurisdictions where they can go and try to enforce their award. But if they're going to come to the United States, they have to make sure that they are not incurring in some kind of violation that might implicate the public policy as it would of any other country. If they're looking to have a global enforcement strategy for their award, they have to be careful to not do things in the arbitration that could incur problems as a matter of public policy in the different jurisdictions where they're going. That's what Conoco did, and it's their own submission that they point to, and that would have avoided any kind of problem that they had coming here to the United States. So we don't think that it is for the U.S. recognized government necessarily in the context of the New York Convention to run around and cure the problems that the petitioners may be incurring when they're litigating with one government or the other. So I don't think that avoids the problem that is presented here as a matter of U.S. public policy.
See if my colleagues have any further questions.
Not me, no.
Oh, okay, thank you. We'll hear from Mr. Conlon.
Good morning, may it please the court. John Conlon, representing Venezuela, US SRL. I'll refer to it as VUS, the appellee in this matter. VUS seeks confirmation of an award against Venezuela based on the refusal of a Venezuelan state-owned company to pay dividends to VUS. Venezuela's objection to confirmation under Article 5.2b of the New York Convention that recognition and enforcement would violate US public policy requires it to establish, first, confirmation of an arbitration award against Venezuela is tantamount to recognition of the Maduro regime, and that such recognition infringes on the exclusive power of the executive to recognize the representative of the
Mr. Conlon, I think you may be correct with where you're going, that we may be able to recognize this award without our court recognizing the Maduro regime. As we did I think that's the holding from a few years ago. I think the problem for you, though, is that we can't recognize this award without holding that it is U.S. public policy to allow arbitration against a nation's people in absentia. Isn't that what happened? First of all, isn't that correct? I mean, do you agree that the nation of Venezuela, their people, were not represented at the damages phase of this arbitration? They were absent.
Well, the recognized government of Venezuela participated in the jurisdictional phase and the merits.
My question is about the damages phase.
At the damages phase, Venezuela was represented by the Maduro regime in that arbitration by.
Okay, but that is to say that the people of Venezuela were represented by fraudsters and imposters who we as our government has said have no more connection to them than the Stuart monarchy has to the United Kingdom. They're over. Their time is over. They're not the sovereign anymore.
Well, I would say with respect to the ability of Maduro regime to act on behalf of Venezuela in arbitrations, that's precisely what happened in the Valores case. The Maduro regime represented Venezuela in the annulment portion of the ICSID proceeding in that case.
I get that, but it didn't matter there whether recognizing that award was in U.S. public policy or not, because ICSID didn't have a public policy exception.
There was no public policy exception, but the court was presented specifically with the question and did analyze the issue as argued by Venezuela that with respect to ICSID, in Valores, Venezuela argued that in exceptional cases, certain courts have held that the full faith and credit will not be accorded to state court judgments regular on their face, where to do so would defeat a vital and overriding federal interest. Essentially, the public policy argument that they're making here.
I read it to say full faith and credit's bar against relitigation is unyielding, followed in the next citation with a parenthetical that says recognizing lack of jurisdiction as a basis to deny full faith and credit, but noting that the Supreme Court's decisions support no roving public policy exception to the full faith and credit due judgment. So what Valores said is that when it comes to full faith and credit, there is no roving public policy exception. But here, there is a roving public policy exception. It's express. It's in the treaty.
But it was not considered under the context of the New York Convention public policy exception, but the very same issues were considered by the court in Valores in addressing these issues. It characterized.
Mr. Conlon, let me ask you this hypothetical. Let's assume for the sake of the hypothetical that Valores is not completely controlling, that it leaves us room to try to figure out whether recognition here would be consistent with U.S. public policy. Let's imagine that there was an arbitration and the damages phase of that arbitration against the United Kingdom, I mentioned this earlier, the descendants of the Stuart monarchs fired the United Kingdom's attorneys and then hired attorneys who purported to represent the United Kingdom for the entirety of the damages phase. And then the arbitrators awarded damages, and then the other side seeks to enforce that arbitration, seeks to get recognition of that arbitration award in the United States. Don't you think it would be against U.S. public policy to recognize an arbitration award against the United Kingdom when the people of the United Kingdom were not at all represented? It's not even a matter of adequate representation. There's no representation. It's the difference between ineffective assistance of counsel and no counsel.
Well, I think if it were like the situation presented in Valores, where under the rules of the arbitral regime, it was proper for, in this case, the Stuart dynasty to represent the people of England in connection with that arbitration, then I don't think it would be against U.S. public policy. Whether that representation was adequate or not under the circumstances would be a separate issue. If the Stuart dynasty did not properly or adequately, under a due process argument, represent the people of England, then I think that's a separate question.
I'll mull that over.
With respect to Valores, this court squarely held that judicial confirmation of an ICSID arbitral award against Venezuela, even where Venezuela was represented by the derecognized Maduro regime during the arbitration process, does not constitute recognition of any government. As this court explained, confirming an arbitral award is not equivalent to recognition of the Maduro regime and does not imply a denial of the president's recognition of the interim government. That reasoning applies with full force here and is dispositive of appellant's argument. In Valores, this court observed that—
Can I ask you a conceptual question
Sure.
about this? Because in considering the public policy defense, do we have to determine well, the recognition power is, legitimately within the public policy defense, and then determine whether it applies. Can we just assume that the recognition power could sometimes be a valid defense? And I mean, can we just go to the second step of that, which is to decide whether here enforcement of the award would contravene the recognition power?
Sure. I think, as Valoris squarely held, it does not. Recognition is a formal acknowledgement that a particular regime is the government of a state, and it's a political rather than a judicial question. And contrary to the argument made by Venezuela, one does not implicitly recognize a foreign regime. Here, with respect, and to the extent your question is, assuming that there is a public policy here, is it the type of public policy that would qualify under the New York Convention? Is that
do we have to decide that question?
No, I don't think you need to get there. I think that confirmation of an arbitral award is fundamentally different from recognizing a regime as legitimate or not legitimate government of a particular sovereign state. Here, the award is against the sovereign state of Venezuela. It is not against a particular regime. It was done, the award was issued based on acts of Venezuela when it was represented by the Maduro regime as the recognized and legitimate regime of Venezuela. Liability was determined when Venezuela was the recognized government, when the Maduro regime was the recognized government of Venezuela, represented by counsel here. The only issue that was determined in the arbitration in which the Maduro regime was not the recognized government of Venezuela was damages. And damages simply consisted of the unpaid dividends, the amount of the unpaid dividends, which was $52 million, plus accumulated interest plus costs. So in terms of making determinations about liability, that was all done under the supervision of the recognized government and counsel here.
I have a question about the procedural question. If I understand correctly, when VUS changed counsel earlier in the proceedings, the Permanent Court of Arbitration invited VUS to provide Venezuela with a letter of representation, which showed the authorization for the new counsel to act on behalf of VUS. My first question is do I have that part correct?
That is my understanding, Your Honor.
Then, did the Permanent Court of Arbitration ask for, and did you receive a power of attorney from the National Assembly during the arbitration proceedings when the Maduro regime purported to replace the Curtis law firm?
Not to my knowledge, Your Honor.
Okay. That's for clarifying.
Separately, although the court does not need to reach this issue, Venezuela has failed to demonstrate the existence of a qualifying public policy under the New York Convention. The public policy exception is to be construed narrowly and applies only in clear-cut cases where enforcement would violate the forum state's most basic notions of morality and justice. As to Venezuela's argument that the recognition power constitutes a qualifying public policy under the New York Convention, the district court observed that Venezuela cites no case finding a public policy issue on facts similar to this case or anything close, and that Venezuela does not even attempt to justify its position that enforcement—
Mr. Conlon, you said we don't necessarily need to decide that question.
You do not. I don't think you need to reach that. I think Valoris is dispositive that you don't need to even get to whether the recognition doctrine is a public policy applicable under the New York Convention.
Okay, let me see. Judge Randolph, do you have any further questions?
No, that's fine.
Okay.
Great.
Judge Walker? No? Okay. Mr. Perla, we'll give you 2 minutes on rebuttal.
Thank you.
Mr. Perla, before you launch into that, there's a question that is not on the record, and I don't expect you to that you may know, but The attorneys who represented Venezuela after the Maduro regime was no longer recognized by the United States, they continued through the damages stage. Is that correct?
Yes, correct. They were purporting to act for the Venezuelans during.
But who paid those attorneys?
Well,
for their services during the damage?
I don't know that for a fact, Your Honor, but I would assume that it was the Maduro regime. I do know that it was not the National Assembly U.S. recognized government.
Okay.
So I think, Judge Walker makes a very good point about the difference between Valores here, which is the distinction between a roving public policy exception and that doesn't exist under the ICSID Convention and that does exist here. And the difference, why that matters, is that not New York Convention awards are like private contracts. And we have a series of cases that we've cited where the contradiction between the enforcement of the contract and the formal recognition by the US government was implicit. It didn't matter. It doesn't have to be, you don't have to sit here as a court and say, we formally acknowledge the Maduro regime. The arbitration tribunal did not have to include a statement that say, we formally acknowledge the Maduro regime as the government everywhere. What you have to look at is the effect. Under the New York Convention is the effect of enforcing the award. And the recognition doctrine can be contradicted implicitly. It was in Pink, and the Supreme Court said, no matter what gloss be given to what the New York Court of Appeals contrary decision is by not recognizing the, and if I may just finish this, Your Honor, in not recognizing the acts of the recognized Soviet government, it amounts to official disapproval or non-recognition of that government. That disapproval or non-recognition is in the face of the underlying policy adopted by the United States when it recognized the Soviet government. So you don't need a formal statement in the arbitration award. You don't need a formal statement in this court's decision. Under the New York Convention, it is the effect of the award's enforcement that is what offends the U.S. public policy, and therefore the district court erred and should be reversed.
Mr. Perla, just a clarification on your answer to Judge Randolph's question. Tell me if this chronology is correct. The Curtis law firm represented Venezuela in the arbitration at the beginning. After that, the National Assembly was recognized by the United States. After that, the Maduro regime fired the Curtis law firm. After that, the damages proceeding happened. Is that all correct?
Your Honor, I'm not sure that we were fired, but we stopped taking instructions from the Maduro regime. And I do appreciate the question, Judge Walker, because I want to make something clear. On page 33 of VUS's brief, they say that Curtis continued to serve as counsel for the Maduro regime after it had been derecognized. And that's just plainly false. Your timing and chronology is correct, Judge Walker. We were acting for the U.S. recognized government during the jurisdiction liability phase. Then the U.S. government derecognized the Maduro regime and recognized the National Assembly. At that point, we began taking instructions from the National Assembly, U.S. recognized government, and we were no longer involved in the proceedings once the Maduro regime then entered with their new law firm purporting to act for Venezuela without giving us any notice.
Okay. There are no further questions?
Not by me.
Okay. Thank you to both counsel. The case is submitted.
This honorable court now stands adjourned until Tuesday, February 24th at 9:30 a.m.